Tonight on Horizon, universities rally at the state capitol as lawmakers prepare to balance the current year budget. And we continue our series on the legislature with a look at why lawmakers are being asked to reform Arizona's initiative process. That's coming up next on Horizon. Joining me to talk about initiative reform is Andy Gordon, a lawyer at Coppersmith Gordon who specializes in election law and has written several statewide initiatives, and Nick Dranias, Director of Constitutional Policy for the Goldwater Institute, a conservative research and policy organization. Thank you both for joining us on Horizon.
Thanks for having
me. Nick, the initiative process, is it hopelessly broken, or can it be reformed, fixed, and sent back on its way?
How about both? If we're talking about the referendum process, I don't think there's anything wrong with that. The referendum process serves the original purpose of the initiative process, which is to diffuse power away from concentrations in the legislature. On the other hand, the initiative process, the side of ballot measures that actually put laws into place and amend the Constitution, there are major problems with that. I think that with the Voter Protection Acts in place, it's radically shifted the balance of power away from the legislature towards direct democracy, which is actually contrary to the genius of our republic.
Voter Protection Act too much right now?
Well, I hope that the notions of whether we need to reform the process actually don't get mixed up with notions of whether the Voter Protection Act itself is working. There may be an argument that we should have the voters change the Voter Protection Act to give more flexibility, particularly in budget times. But the fact that the Voter Protection Act may need some work doesn't mean that the process of passing initiatives itself needs some work. And those are two really separate questions.
Let's talk about the initiative process then. Is there too much power given over to a direct vote, just a direct democracy, mob rule, some would say? Is there too much there by way of initiative?
No. When Arizona became a state, the initiative referendum and recall process was built into our Constitution as part of a populist movement that was concerned about special interests controlling the legislature. I think that's as big a concern now as it was when the robber barons controlled Arizona. So we need to protect that process. The Voter Protection Act, it's important to keep in mind, was passed by the voters because the legislators kept ignoring what the voters wanted to do. We need both of those at work.
If you have an initiative process, how can the initiative process survive if every time something is passed by the voters, the citizenry, the legislature goes in and changes it?
I think that's an overstatement. It didn't happen every time. I think that what's important is maintaining a tension in government to maintain a diffusion of power between the legislature and the people. We want the people to be concerned that if they go too far, the legislature might just repeal it. We want the legislature to be concerned that if they pass a crazy law, then the people just might rise up and have it overturned by referendum. That tension is exactly what we want in our system.
But did we not see voters react to that tension by saying, we're tired of the tension, leave it alone?
And I think they made a mistake, because what they did by putting the Voter Protection Act in place is they transformed what was originally an initiative process into something that almost amounts to an effective constitutional amendment process. It is so difficult for anything to be done to change an initiative that is now enacted because of the Voter Protection Act that it totally changes the balance of power in our state government.
Actually, that's not true, with all due respect. If they want to change the Voter Protection Act, all they have to do is refer it back to the voters and say, do you think we ought to change it? The voters always have the power to change that. What the Voter Protection Act was protecting against was the legislator changing what the voters had done. They had done it repeatedly, which gave rise to vote. Are we now finding in this particular budget crisis that the Voter Protection Act isn't a perfect piece of legislation? Yeah, I think we are. We find that in stuff that the legislature passes all the time too.
Does it make sense to maybe suspend VPA for a year or two, or maybe trigger it to where if a deficit hits a certain amount of the state budget, you go ahead and suspend Voter Protection Act?
I think there are a number of ways of trying to tinker with the Voter Protection Act to help us through the budget crisis.
Those ideas make sense to you?
Depends what the word tinker means. I think that we need something fairly strong. I'm not so sure that we have to even begin with the Voter Protection Act. How about a sunsetting amendment, something that says that any initiative law that's passed will sunset after, say, 10 years. Make it even 15 years. But something that makes it clear that when we effectively amend the Constitution through the initiative process, that it's going to go away at some point in time, that this isn't a permanent transfer of power away from the legislature back to the people.
You have authored initiatives in the past, and first of all, can you just give us a capsule summary of what the heck happened with the Time Initiative?
What happened in the Time Initiative was it's a very technical question. It is, when was the right time to challenge the actions by the Secretary of State to disqualify some signatures? The statute was very clear on when you did it if you're challenging what the county does, what Helen Purcell's office does, but it doesn't say what to do with the Secretary of State. The Arizona Supreme Court, with all due respect, I think got it completely wrong. They decided to go with the shorter time limit that was in there for the county, in part because of the court's concern of the burden on the election officials and the burden on the court, without taking into consideration that the overall concern here is to follow the will of the people, that the courts have traditionally been deferential to the initiative process. So if there was an open question, rather than worry about their own work schedule, they should have worried about all those people who had legitimately signed the petition. But it was a technical timing question.
Does that become a de facto control on the initiative process?
I think that's the wrong kind of control. I think at this point, Andy and I are going to agree. The timeline that the Constitution and current law gives folks to gather signatures, to have them certified, is just too short. I think that a legitimate process should back that up a little bit, maybe another month or two, so that we don't have the insane, shoot from the hip type of legal actions that result.
Some other ideas out there. The number of examined signatures, should those be increased, decreased? Should there be some set policy instead of 95 to 105, whatever that formula is?
Well, I happen to think we should just follow the plain language of the state constitution. One of the concerns that I have with the statute is it uses sampling. In reality, we should back up the time frame allowed for scrutinizing the signatures. We should fund the agencies that do that adequately to do it, and they ought to actually scrutinize signatures and not rely on a formula or random sample.
Can you examine signatures in an initiative process without using sampling?
Well, you could, but it's pointless. I mean, the fact is, the random sample process works fine. We do things statistically all the time. We do need to adequately fund the offices to ensure that they have enough people to do the work that the election process requires. I mean, the elections, we totally agree, is key, and so those offices need to be funded to do the work. I think it would be silly to count every signature. I mean, I don't need proof that the world is round. The world is round.
We just heard the governor with some suggestions, including registering paid circulators. You like that idea?
With all due respect to the governor, the former governor, that's totally unnecessary. The circulators are already under oath as to their name, address. If they lie, there's plenty of things to prosecute them on. And if they're going to lie on their signatures when they turn in the petition, they'll lie in the registration. That's not going to get you anywhere.
Firstly, I totally agree with Andy on the registration of signature. But even more fundamentally, the U.S. Supreme Court has held that you cannot just impose a prior restraint on the exercise of fundamental First Amendment rights, and petitioning your government to achieve the enactment of a law or the repeal of a law is probably the essential form of petitioning your government.
Yeah, I want to follow up, because we strongly agree on this. What people are overlooking in the details of the debate in light of the time Supreme Court is we're talking about a fundamental right here. It is the right to go to your government to get laws passed, and this is it in its purest form.
Okay, how about payment by signature? What do you think of that?
You know, I think the notion, someone said, you know, these cases are never prosecuted for fraud. Well, that may be because there isn't much fraud. I don't know that it would make a heck of a lot different to do it one way or the other. I I'm very worried about the law of unintended consequences, which seems to be particularly prevalent in this area. If they're violating the law, there's a lot of basis for prosecuting now. I'm just not sure that's necessary.
Tell a guy that I'll give you so much money for so many signatures, and you're getting paid by the signature. Is that a good idea?
I think it's an idea that the Constitution prevents us from regulating. You have someone earning a living exercising yours and his First Amendment right to petition the government. I can't think of an example of something that deserves more First Amendment protection than that as a matter of principle. Now just getting back to the random sample thing, I think that Andy's right. We don't want to have to count every single signature, and maybe I made an overstatement on that. But what we want to do is make sure that the sample we get actually is 100% consistent with what the finding has to be under the Constitution. There shouldn't be a range of 95% to 105%. If you draw a random sample, then in that random sample you should actually demonstrate that you're approaching much closer to 100% valid signatures than what the law currently provides.
That could be.
Yeah. Okay.
Yeah.
Regarding naming of initiatives, which kind of got some attention here this last go-around, reform due there?
I don't think there's anything you can do about it if you respect the Constitution. If you believe in free expression, free speech, giving voice to the person who's actually putting the petition before the voters, the government really can't go in there and censor how that is framed. So I just don't think you should touch it.
Well, I agree with that. It's got the highest level of First Amendment. And no one's talking